Talk about the legal issues involved in today's hearing and what happens next in this case. Let's bring in our legal analyst, Larry Yellen. Larry?
Well, as Craig said, there was a lot of legalese today, but at the heart of the case is what is hearsay and when should something that is hearsay still be allowed in court. Let me take you back to law school, to my evidence classes. Let's say there's a case, Bob, where you're accused of running a red light, and you're accused by a guy named John Doe. He's the eyewitness. He calls me, and he says, Larry, I saw Bob run that red light. Well, who's going to testify against you at court? It's not going to be me because I only heard it from John Doe. I'm the hearsay witness.
Right.
John Doe is the real witness. But what happens if Bob Surratt does something to make John Doe disappear? If you throw him into the Chicago River or somehow make him unavailable? Well, the courts have come up with an explanation for that, for how to deal with that situation. Through years and years of court opinions, they established a rule called forfeiture by wrongdoing. You forfeit the right to confront John Doe, to confront that key witness, because you're involved in some wrongdoing that made him disappear. Prosecutors in this case were a little worried that that was too vague, that it might not get the evidence in that they wanted, so they passed a law, or they got the legislature to pass a law. That was what's known as Drew's Law, and essentially that said that if the evidence is reliable and also that you did in fact make the witness unavailable, then under that law the hearsay evidence can be allowed against you. At issue in the court today was which should apply, the state law or the years and years of court opinions. The prosecutors got the state law passed, but now it turns out that under that state law it's pretty technical and the evidence might not come in. They ended up actually arguing against that and they said let's use the years and years of case law or common law as it's known to get the evidence in. We have to wait to see what the outcome will be.
So if you don't mind summarizing your law school class for a second for everyone, the bottom line here, the issue that we're talking about here is what?
Essentially, there is hearsay evidence in this case. The key witnesses are unavailable. Can somehow the evidence that they have get brought into the courtroom anyway because the defendant made them unavailable? And what rules should apply to determine that?
Professor Larry Yellen. Thank you, sir.
Hope you understood that.
I think the second time I did.
Right.
We have an entire archive of the Drew Peterson case online. You'll find it under the News tab at myfoxchicago.com.